All right. So, welcome everyone. Thank you so much for joining us tonight. We're going to be doing a quick review on IEP Basics, and this is for our Education Advocate Retraining series. The hope is that after this year and the first part of next year, where we're doing one-hour session a month, we'll have a video library built. So, in future years, you'll just be able to go onto that library and watch one of the videos, answer a couple questions afterwards, and then you're done with your retraining, and you can do that whenever you're available during the year. So our learning objectives tonight, we're going to do a quick review on education advocate responsibilities. We're going to talk real quick about evaluation, eligibility, and FAPE, that free appropriate public education. And then we're going to go over required IEP components, goals, a little bit of transition, and then least restrictive environment. So our Kansas State special education law specifically defines who a parent is under special education. So a parent is a natural or biological parent, an adoptive parent, a person acting as parent, a legal guardian, which means the guardianship has been awarded by the court and that child would no longer be in DCF custody, or an officially appointed education advocate. These are the five people that can sign consent, notice of meeting, and release of information, and everything else that goes along with being a parent on special education. So, person acting as parent means a person such as a grandparent, a step parent, or an other relative with whom a child lives.
I have a
So,
question about this.
yes.
So, what is the law? I understand the law to be if the parents are unknown or unable to be found.
Mhm.
How often is that used, and what is the time frame for that?
Okay, so I would say, and we have little bit more information coming in a couple more slides, but about 90% of our kids, their parents' rights have been terminated. Probably about 10% have whereabouts unknown. And there's a lot of factors that go into that. We need to know if there is correct contact information for the biological parents. Do you have a current phone number? Do you have a current mailing address? And then have you have you heard from the parent? Have you spoken to the parent? Has case team heard or spoken to the parent? I would say within the last 2 to 3 months. Um, and there's a very fine definition between unavailable and unwilling. And state statute makes that clarification that an unwilling parent, that's within their rights to do so. And so we can't take away the special education rights. Whoops, sorry, guys, in that instance. It's really a case by case scenario. We ask lots of questions when someone says, gives a referral that they can't get in touch with a parent. Um, Being incarcerated or in a rehab center does not make them unavailable. We know where they are, and they can still receive phone calls, sometimes do virtual meetings. They can still receive mail.
Homeless?
Homeless, it would, again, then my next question would be, do you have a working phone number? And if the answer is no, then I would say that parent would be unavailable because you don't have a physical address or a working phone number. So you can't
It's
mail
just
them.
it's difficult to wrap my head around parents that neglect their children and won't get their special needs met, how that is justified. I really don't understand that.
I completely understand it. This is probably one of the hardest parts of Lori and I's job. Um, and the reasoning behind that really is that only a judge can take away parental rights. And that's what we're doing. We're removing those special education rights from the parent and we're transferring it to another person. And only a judge can make that decision.
Okay. But a
There
judge can.
Absolutely. A judge can
Okay.
absolutely, well, the court order needs to be against the parent. The court order, the judge would need to rule that the parent is educationally unavailable or not able to make educational rights.
Okay.
We can't just,
I'm not looking for that to happen. I just
yeah,
ran into that and it was very disturbing. I mean, I
I
knew the law,
understand.
but um it makes me feel better a judge can overturn that
Mhm.
or okay.
Yep,
Thank you.
you're welcome.
Sorry, I have a question to kind of piggyback on her what she
Yeah.
said, but what do you do if the child cannot be found?
If the child cannot be found, contact us because we have ways of finding the child. We can contact case team, educational coordinators. We have a list of people that we go through, and we can usually find the child within 1 or 2 days. That when you are not able to locate one of your kiddos, we're really on top of that, and that's a high priority for us to find out where they are and where they're attending school.
Okay, well, I mean, I have a kid on my caseload right now, not through you all, but
Mhm.
and he hasn't been at school at all this year. Like
That's not good.
mom is on the run, I'm assuming, and so that's what I mean by can't be found. Do you just put everything on hold? Do you keep the IEP in place? I mean,
Okay. So in that case, what would usually happen, the IEP would absolutely be put on hold because there is no parent to sign them out of services.
okay. Because I
We
do have
might,
I have access to one parent, but not the child, I guess if that makes sense. So like, yeah, the parent
so
with
they,
custody, I have access to the parent with custody, but
okay.
I don't have access to the child. So I didn't know, do you just put it on hold and wait? Or do you, I mean,
So I would, in a case like that, I would ask the school to put the IEP in what's called a willing and able status, to where the parent would sign consent that they understand that their child's not receiving services during this period of time, but the school is willing to go back into that IEP as soon as the child is found and enrolled in school.
okay, and it's called willing and able
Mhm.
status. Okay.
Yeah,
Okay. Thank you.
you're welcome.
Quick question from David. Can a parent
Yeah.
abdicate to the foster parent, and is there paperwork for that?
I'm sorry, say that one more time.
Can a parent abdicate to the foster parent, and is there paperwork for that?
Can the parent advocate for a,
Abdicate to the foster parent.
oh, no, it has to be from a judge. Even a power of attorney does not extend to special education rights. If you have a power of attorney signed by a parent, that only encompasses general education, not special education. So there has to be an order against the parent from the judge. Now, the parent can absolutely invite whomever they wish to that IEP meeting. So the foster parent can be invited to the meeting, can be a part of the team, can give their opinion, but at the bottom, at the, that consent level and signing the prior written notice level, the parent is still the only one that can do that. Okay.
What if a judge makes an order that the rights have not been terminated? And how do you know if the foster parents have those rights?
Okay, so the judge made an order for
Um,
that the against the parents, that the parents are not educationally available.
well, so what happened is the um, the judge made an order assigning me as the educational advocate, but the parents' rights had not yet been terminated. So what happens in that case?
So in that case, we would send our guidance from KSDE is to send the court order to our lawyers at KSDE, um, who we contract with to run the Education Advocate Program. And then they will send a letter out to case team and to the school stating that we will not be appointing an advocate because they do not meet those federal guidelines.
Thank you.
You're welcome. Yeah, this The special education law is based on the federal IDEA laws, and that those are the minimum laws that the state has to follow. And one of those is that the state board of education is solely responsible for appointing education advocates. And so that's why we have to have that court order going against the parents versus for the child to have an advocate.
Hey, I got a question.
Yes.
Are we responsible to go to like the kids that we advocate for, the parent teacher conference and stuff like that?
Great question. No, you are not. You can if you wish, but that is parent teacher conferences is a general education action. And so the foster parents case team, they can go to that. Now you can schedule an IEP meeting at that time if you wish, but you should have access to the parent portal so that you have all that information.
Okay, thank you.
Yep. Okay, so on that note, we're going to go through this list real quick. So caregiver is going to be foster parent case team, and parental consent is going to be who can sign that IEP. So a field trip permission form, is that a caregiver's responsibility or is that an education advocate responsibility?
Caregiver.
Caregiver.
Caregiver, very good. Enrolling the child in school.
Caregiver.
Caregiver.
Great job. Consent for a special education evaluation.
Parental consent.
Yep, that requires parental consent, so an education advocate. A power of attorney, we talked about. Power of attorney only gives general education rights. How about adding an accommodation or service to the IEP?
Parental
Educational advocate.
educational advocate.
Yep, that requires parental consent. Scheduling the IEP meeting.
Parental
Parental
consent.
consent.
Parental consent.
That is education advocate. Yep, that is parental, whoever has those parental consent rights. What about 504 plans?
I think that's educational advocate.
So 504 plans are actually
Caregiver.
caregivers. Yep. 504 plans fall under general education, case team, and foster parents. And, oh, looks like there's someone that's not on mute. Okay. Maybe Sharon, I think. Can you mute yourself, please? Or Brian, can you help her? So consent for 504 plan evaluation falls under general education. Foster parents can request that. Foster parents can sign it. And so that is an option for those times when a parent is unwilling for a special education evaluation, maybe going that route to get something in place with the school. Receiving IEP progress notes. Who should be getting those?
Caregiver.
Both.
It actually should be the education advocate. So when we look at education advocate as the parent, they have the same rights under FERPA as a biological parent. So unless there's a release of information on file, special education information, IEPs, should not be given to foster parents or case team, which is one of the reasons why in our training we ask everyone to sign those releases of information when you first are appointed as an advocate. Okay, do we have any questions on those?
Yeah, so when you say an ROI for that, I've received many progress notes on children. Is that just a school ROI in general, or is that actual school advocate ROI?
It can just be a general release of information stating that the educational decision maker can consents for the release of special education records to the foster parents and to KVC or St. Francis Ministries or anything like that.
Okay, thank you.
Yep, you're welcome.
If you are a foster parent and you're also the educational advocate, could you invite like my spouse to the IEP meeting?
Absolutely.
Okay.
Absolutely. You can, the educational decision maker can invite anyone who has knowledge about the child. So that can be the spouse, that can be a therapist, case manager, any of those people you can invite.
Okay, thank you.
Yep.
Quick question from Jennifer. Do EAs or education advocates have the right to power school for monitoring grades and notes?
Yes, they absolutely do.
A question from Judy. If a child is in an PRTF, should the school at the PRTF be following the IEP?
Yes, they should. Or holding an IEP meeting to rewrite it like a 30-day walk-in IEP, like when they switch schools, you have that meeting usually within 30 days to change the IEP to the new district's schedule or the services that are provided. So yes, that should be happening at PRTFs as well. All right, guys, great question. So real quick, who qualifies for an advocate? They need to be between 3 and 21 years of old. They need to be in DCF, Department of Corrections custody, or listed as homeless and unaccompanied under McKinney-Vento with the district. Have those unknown or unavailable parents, be receiving special education services or in need of an evaluation. Again, that 504 plan falls under Gen Ed. We will actually appoint an advocate at about 2.5 years of age, just because consent for an evaluation needs to be signed in order for services with a district to start at age 3. So we kind of went over this as well. An unavailable parent means their rights have been terminated or relinquished. They are deceased. Court order of no contact exists, and the parent is not to know where they're located. The parent is unknown, or we don't know where they are. Their whereabouts are unknown. And this is that difference between whereabouts unknown and an unwilling or uncooperative parent. A parent who can be reached by phone or mail or personal visits is not unavailable, even though they don't respond. So an appointment being made, what happens when you say yes? A referral is made to families together. This could be made by the contractor, by a CASA, foster parent, the school. We process that referral, make sure the child is eligible. Well, we will appoint the foster parents if they're trained, or contact trained advocates in the area. And then once assigned, we'll email the student information to you, and an appointment letter will be sent. Appointment letters are sent from Becky. Letters are also sent to the principal or the early childhood coordinator for the district, the case manager, you, and Families Together, and KSDE. It is password protected. Passwords are easy to remember. We follow the school semester, so August through December. The password is fall and then the year. So right now our passwords are fall 2024. And then January through July, the passwords are spring and then the year. So starting in January 1, all letters, the passwords will be spring 2025. When you get the letter, contact the school, request their current IEP and educational report, introduce yourself, ask to be put on that parent portal, the campus or Power School or Tyler. Get some background information from the case manager and stay engaged.
I have a question. Who do you get the information from if the case manager is unavailable? Like I just picked up a student who has a case manager in limbo. Like they don't, so she really doesn't have one.
Send us an email if that happens, and we can find out who the interim case manager is, or we can get you to the educational coordinator that's over them, and then they should have at least some information for you to go on.
Okay.
Okay. All right.
Jennifer, really quickly, if a foster parent is not having the kids do homework, what rights do education advocates have to help follow through with that?
None. Your rights are to make sure that the student is receiving a free, appropriate public education in school. If it was my advocate kiddo, I might send an email to case team and let them know of the problems that the school is reporting. I'm assuming it's the school that's reporting this back.
I notice it on Power School when they're missing assignments, and I bring it up to the school and they say yes, we send it home. And there's times where like field trip forms aren't signed, and so they reach out to me and I'm like, I don't have the right, I can't sign that, you've got to get foster parent to do it. And then there's also times where, and this was for elementary kiddos, and then I had a high school kiddo who was self-advocating also. She was attending her meetings, and she was struggling with the homework assignments, and her foster family didn't really know how to use the resources available to them as far as checking her assignments and whatnot. So the principal and the staff, the IEP team, we came together and said, look, you're going to go, we told the student, you're going to go during, this class period to this teacher and make sure that you understand what you were supposed to do during that other class. And you're going to use your, once a week, you're going to do after school study time instead of going to the practice, this athletic practice that you're engaging in. And, just got the athletics on board with that. And then also the case team also kind of knew that the parent picked up after athletics anyway. So it was, well, she can go to the program after school instead of going to the athletics once a week. So I didn't really cross the line because I didn't make that decision, but I was also there for that conversation. So I just didn't know really like how much I can really kind of push on that.
I think that's perfect how you handled it, because our role as advocates is working with the school, but there's outside, forces that affect that. So going back to the school and saying, I know this isn't getting done. We need to get it done. How can we work together to make sure it's getting done? I think that's perfect.
Okay.
Yep. All right, we are going to go real quick through evaluation process. If you are assigned a kiddo that needs an evaluation, you'll receive an introductory letter from Lori or I, and the appointment letter from Becky. It is your responsibility to contact the school. Make sure that you're listed as the parent and or the educational decision maker, just like any other child. Attach a copy of your appointment letter and ask for that access to the parent portal. And then we want to start gathering some school records. Send an email to the school psych, the school counselor, ask for their latest benchmark assessments, their latest reading assessments, and any behavior referrals. And then connect with the case manager and the foster parent to try to see why they thought the child needed a special education evaluation. Typically, we don't receive much information regarding why the evaluation is being requested. So connecting with the foster parent or case team might help with that. Call and ask for an email, the school psychologist or the IEP coordinator. We want to request the students' records to help determine if they need that evaluation. And after you review the records, if you see progress is not being made or there's a, influx of behavior referrals, then go ahead and send in your letter. We will attach a draft evaluation request letter to the introductory email that we send, and just fill it in with the student's information, put in what you noticed from the school records, and email it to the school to request that evaluation. We rely on you to help us know where in the process that is. So you will probably be hearing from us about 2 weeks after you're appointed, just to make sure that that you've reached out to the school. And then we'll be checking in probably monthly, just to see if we've had that eligibility meeting, if they are eligible. We've had some instances in the past where kids have kind of fallen through the cracks, and they were referred for an evaluation and things didn't happen. So that's one of the processes that we have in place that we very strictly follow. It's not that we don't think you're doing your job. We just want to check and make sure that the kids are getting what they need. So once the evaluation is complete, the school will hold an eligibility meeting. To be eligible for special education services in Kansas, a child must meet a three-pronged set of criteria. They must be between the ages of 3 and 21. They must meet the eligibility criteria for one or more of the 13 categories that we have in Kansas. And they must not only meet that eligibility criteria, but they must demonstrate a need for special education services. Kansas goes above and beyond federal law on eligibility because we do serve gifted as well under special education. And the federal law allows states and districts to set eligibility criteria. And the Kansas State of Education has eligibility indicators on their website, which most districts follow. However, eligibility requirements are set at that local level. So you could request that information before the eligibility meeting from your district or cooperative to see what their eligibility indicators are.
Quick question. I have found it difficult for me as a foster parent and a trained education advocate to get my kiddos evaluated for an IEP. Is there anything I could do differently to get the school to see me as an education advocate and not just a parent or caregiver?
So I think making sure that they have your appointment letter and that you are listed as the legal education decision maker. I also think that using the draft evaluation letter that we send out is helpful because at the bottom it has on there, I understand that by submitting this evaluation request, I will receive a written notice within 15 school days of your response. And I think that's an important piece to have on there. If you feel like you are not being heard, it could be because general education teachers are reading that information and they do not understand themselves what the difference between a foster parent and an education advocate is. So if I have trouble with a kiddo that I'm advocating for, I will keep sending emails and I will add on the next person up in that staircase letter at the district or co-op. So I will have no problem if I'm not getting a response or I'm believe that I am not getting a correct response. I'll add in the district or the co-op special services coordinator, the special education director, and adding in those people that have that knowledge of what education advocate is. So maybe some training can be done with the general education people that's looking at that. Does that make sense?
It does. Thank you.
You're welcome.
Actually made a lot more sense. We have a lot of problems out here. I won't say where we're at, but we have a lot of problems with the public school out here.
Okay.
They do not love it when the foster parents become the education advocate also. And so far we've had 2 kiddos here
Oh, wow.
that we've advocated for, and it has just been so difficult.
Okay. Well, another option is CC me on those emails. I am more than happy to chime in and put my 2 cents in on there.
Speaking
I
as
will
someone
definitely
who's
do that.
on both sides of this process, because I'm a high school special education teacher,
Mhm.
that speaks to more as people not willing to do their jobs and potentially provide services. Because if they meet any one of those, or if they have a need, then someone somewhere is just not doing their job and something needs to happen.
Yeah, and I think adding in those district level people will help with that definitely. So,
And depending on if your school, as a special education teacher as well, like depending on if your school is, depending on where the special education service is coming from, this district or a co-op, you could always reach out to the co-op as well if
yeah,
it's
absolutely.
through the co-op.
Absolutely.
Yeah, that's
All
good to
right.
know. Thank you guys.
Yeah.
Few more questions really quick. I have a child who's currently on the SIT status. How long will it take for him to get evaluated for an IEP?
Okay. So this is something that some schools like to do to push off that evaluation. Um, there has to be data showing that the child needs a special education evaluation and that general education interventions do not work. So the SIT team, student improvement team, and they're called different things in different areas. It has a purpose, and we need to make sure that that general education interventions are not working, and that is why we need that evaluation. Which is why when you are requesting an evaluation, it's important to get those school records and review them and see if they really do need that. Whenever I have a kiddo that I'm advocating for now that's in a SIT status, and we are in September, they asked to try a few more things, and I said, okay, so let's meet again in a month to see if those general education interventions are working. So asking to put another meeting on the books to see if those interventions are working, and then if they're not, then why are we not moving forward with an evaluation? And also asking in writing is really important. Even if it is sliding a piece of paper across the SIT meeting table and then emailing a follow-up, because then they have to give their response in writing on a prior written notice. So it's a process. Sometimes it's a slow process. SIT teams absolutely have their place and they are important, and sometimes it's all they need. But we just want to make sure that it's not continuing on and on and on and on, because if general education interventions are not working, then we need to find something else that will.
Can I just add, just because there is progress does not mean they're always working or that it's adequate progress, because you have to look at the gap. And I deal with that a
Yes.
lot in SIT teams. I hear, well, we don't want to evaluate because they're making progress. But right now, for example, I have a third grader who is reading a 37 word per minute and she needs to be at 101. Well, she's making progress. It's up from 24, but is it adequate progress to keep her on level with her
Right.
peers?
Right.
Because a
And
lot
that's
of
where
schools I
we,
know like to say, well, they're making progress, but
right.
is the progress closing the gap or not?
Right. And a lot of that comes back to FAPE. And we have a couple slides about that in just a few minutes.
Now, Lisa, with him being on the SIP program, and the situation that I'm running into is the fact that both of these boys was homeschooled before they came to us. So what kind of information are they going to be able to get from these parents with them being homeschooled in order to do? Because I just went for his conferences today, and he's very behind. I mean, he's in fifth grade, only reading at a first grade level.
Okay. Sharon, I think can you send me an email, or Brian might jot down your name, and I'll give you a call, because there is an exclusionary factor of lack of education for an IEP and special education services, which could be where they're going with this.
Okay.
But I, I think I just need to have a conversation with you about the more intricacies of this specific case.
Okay.
Okay. All
Couple
right.
more questions
Oh,
really
yeah.
quickly. I have a 3-year-old who's in pre-K and doesn't do well in morning classes. Can I ask for him to be moved to the afternoon class?
Okay. You can absolutely ask anything you would like. Um, is and the school is allowed to say no as well. In the IEP team, anything like moving classes, changing teachers, retention. The IEP team can make recommendations, but those kinds of decisions usually come down to building administration to have that final say on whether that happens or not. So yes, you can ask. They do not have to say yes, though.
And then one more really quick. If a child has an IEP and transfers out of district to a new school, how long does the new school have to enroll the student and to start the IEP and get free and appropriate public education?
Okay, so under ESSA, that's that Every Student Succeeds Act. It states for foster children, there should be immediate enrollment regardless of the receipt of records. It also states that the receipt of records should be given within 1 business day. Now, we know that that is not realistic a lot of times, so some grace to those receipt of records should be given, but by some grace, I'm talking about a couple days, not 3 weeks. But under ESSA, it states immediate enrollment regardless of the receipt of records. All right. Any more questions right now?
I have a quick one.
Yeah,
So is traumatic, like mental health issues, covered in this chart by the emotional disability or the other health impairment?
absolutely. Yes. So these are the 13 exceptionalities that a child can be found eligible for in the state of Kansas. A medical diagnosis is only required for other health impairment and orthopedic impairment. So you do not have to have a medical diagnosis for any of these other disabilities. But behavior and social emotional needs and executive functioning skills, those all fall under standards, and those can all be part of an evaluation or part of an IEP. So that being said, with the medical diagnosis, it also means that just because you have a medical diagnosis does not mean they'll qualify for special education services. Remember, we're looking at data and if there is a need for that specialized instruction. All right, so we have the evaluation results and we have the eligibility meeting, and now it's time to determine if the child is eligible. And this is where we talked about those eligibility indicators and determining if they need that specialized instruction. So if you disagree with the evaluation results, if they say, nope, we don't think that he is eligible, and you disagree, respectfully state your disagreement in the meeting. You write that you disagree with the decision next to your signature. You can email the district or the co-op and ask them to review the results and say, I do not agree with this because of these reasons. I would like a meeting with you to review it. And you can also request an independent education evaluation where where the school will pay for an outside evaluation. Now, just like any other evaluation, the school has to consider that outside evaluation, but they do not have to follow it. And then we have our reevaluation, which happens not more frequently than once a year unless the parent and the school agree otherwise. And it happens at least once every 3 years or more often. And on the reevaluations, they do not have to do the full evaluations over again. They can use existing data. Okay, so let's talk about FAPE real quick. The most important principles of IDEA, that Federal Individuals with Disabilities Education Act, is the concept of a free, appropriate public education. So free means that special education and related services are provided at no cost. Public obviously means it's a public school act. Private and parochial schools who do not receive federal funding are exempt. Education means only what the child needs educationally to receive meaningful benefit and make sufficient progress. The child may have other needs, such as medical needs, therapeutic needs, but unless those needs interfere with their child's learning, they do not have to be addressed in a school setting. And then appropriate is that tough word. What is appropriate will have to be determined by the IEP team, which includes the parent. And the law says that children should receive meaningful benefit from their educational experience. And this is where we get that definition, that new definition of FAPE. This is a Supreme Court's case that centers around Andrew, a child with autism whose parents believed his IEP was not providing the educational benefit he needed. Andrew is an autistic fifth grade student who was placed in private school because his parents believed the public school education was inadequate. And he was placed in that private school, and his parents sued for reimbursement for the tuition and related expenses. They argued that the school's program was inadequate, leading them to enroll in the private school. After years of legal battles, the Supreme Court ruled in their favor, establishing that higher standard for IEPs. So in order to provide children with disabilities, FAPE is guaranteed under IDEA. School districts must offer children an IEP that is reasonably calculated to enable them to make progress appropriate for that child's circumstances. When Chief Justice John Roberts delivered that opinion for the ruling, he allowed that the IEP is reasonably calculated to allow a child to make progress, is intensive, fact-specific, and therefore neither the court nor the statute could create that substantive standard. So it suggests appropriate progress for most children would allow them to be fully integrated into the classroom and to advance from grade to grade. This requirement is substantially more than the de minimis benefit that the school district argued was all it was required to provide. However, the court also held that the standard that Andrew's parents argued for was too rigorous and was similar to the one that the court had rejected in another decision. So the reviewing court should give deference to the expertise of school authorities, but must also still ensure that the IEP is reasonably calculated to enable each child to make progress. The key takeaway is that schools are now required to provide programs that allow for meaningful progress. This means that the goals in the IEP should be challenging and tailored to their specific needs rather than being generic or just about passing grades. And it also requires IEPs to be developed with expertise from the schools and input from the parents. And schools must give responsive explanation for their decisions on services. All right, so we have our IEP together. We're going to review really quickly who the IEP team is. It is the parents or educational decision maker, not less than one regular education teacher of the child, not less than one special education teacher, and a representative of the local educational agency, so the district, who is qualified to provide the provision of specially designed instruction and is knowledgeable about the general education curriculum and about the availability of the resources. This is usually a school administrator. An individual who can interpret the instructional implications of evaluations, that's usually the school psych. The child, when it's appropriate, or if they're over the 14, they're required to be invited. And then other individuals who have knowledge or special expertise regarding the child. And this is where we were talking about earlier, where foster parents or parents or advocates can invite anyone with that special expertise to the meeting. So attendance, an IEP team member may be excused if the parents and agency agree that the individual's attendance is not necessary, but that member's curriculum area or related service is not being discussed or modified. And these four parties require written consent from the parent before the meeting to be excused from the meeting. The regular education teacher, the special education teacher, the individual who can interpret the evaluation, and the district representative. I have seen at the beginning of meetings where schools might push a form across the table and say, oh, I'm sorry, the general education teacher can't be here today. Can you sign your consent for them not to be here? It's okay for you to say, oh, no, I'm sorry. It's really important for the general education teacher to be here since they will be the one implementing a lot of these accommodations in the IEP. Let's reschedule. That is perfectly okay for you to say.
Couple questions really quick.
Yes.
When was the year that the Andrews Supreme Court case made their decision?
2017, so not that long ago.
And can an out-of-home education advocate observe their assigned kiddo in the classroom setting to get a real sense of the child outside of what's on the paper? If so, do many education advocates do so?
I do not believe many educations do that. If they can or not is going to be up to the district guidelines. So that would definitely be something that you would need to talk to the district about. I do have advocates that have done that before. I also have advocates where the schools have said no. If you want to, and the school says no, send me an email, give me a call, and we can kind of talk about that and ask the district for the policy that they're referencing. Okay. All right. So real quick, guys, we have about 15 minutes left of our time. So IEP process, I'm going to bring your attention just really quick to the really cute picture of the guy in the middle. He is my youngest son, Gavin. He doesn't look like that anymore. He's 17, but when he asks if he can drive to Junction City to see his friend, this is the picture that pops into my head when I automatically say, no, are you kidding? But then, of course, I'm like, oh, right, you're 17. Okay. So we're going to talk real quick about the IEP process, because first we need to know who the student is. And this is summed up in these present levels of academic achievement and functional performance, the PLAF. I really like saying that acronym. I might try to insert it as much as I can. So the present levels include the student's strengths, their preferences, their interests, and their needs. The first step in writing in an IEP is to observe and know the child's present levels of academic achievement, how they're performing. This is the foundation that the IEP is developed. They must be observable, measurable, written in understandable language, relevant, and must be something that is addressed in the IEP. It must include the strengths of the student and also address the concerns of the parent. So some questions we might ask: what are the student's unique strengths, talents, and interests? What do they want in life now and in the future? So a question might be, what do you want to do after you graduate? And also, what would a perfect school day be for you? What are some things the student struggles with day to day? And what are some resources in that school and community to help the student when they get older in high school? This is going to cover social skills, sensory needs, communication, academics, fine motor skills, social emotional. We want to make sure that we have a complete picture of our child right then in that moment. This is an awesome little, let me see if I can click on it. Oh, it might not let me. So if you go to this website, this is called the College and Career Competency Framework. And KSDE has adopted this into its standards for all general education students. So we want to make sure that we have their present levels on their executive functioning skills, their adaptability, their creative thinking, their critical thinking. And if you go to the website, you can hover over, let me see if I can, you can hover, yeah, it's not going to do it, guys. You can hover over each of these words and click on it, and it takes you to another page that gives all types of goals, services, accommodations that match that word. So you can see where your child is struggling, and then this will give you some ideas on how to address that in school. It's a really cool thing. And I will send out PowerPoint slides after this, so this website will be on there. All right, so we know who the student is. Next, we're going to look at what will the student learn. And this is going to be on our goals. Goals must reflect what the student can reasonably accomplish in a school year. They need to identify a specific area of focus, a need that was identified in their present levels. They must include a direction or action, reflect reasonable expectations, and tied to the general education curriculum. So it is not our job to write goals, but we do want to be able to recognize a well-written goal. So a goal contains 4 parts: the behavior, which is an area of need, the condition, the criteria, and the timeline. So a behavior is what you expect your student to do. Sarah will read. Scott will initiate interaction. The condition specifies the manner in which the student will progress toward that goal, how it's measured, and involves the application of skills or knowledge. It specifies what materials will be used, describes the setting, under what circumstances, and with how much support. So using second grade reading text, using preferred words and coping strategies, with fading adult support. The third component is the criteria. It identifies how much, how often, and to what standards the behavior must occur. It's often identified by numbers or percentages. So 80% of sight words with no less than 3 errors. 90% accuracy as measured by anecdotal records. And then lastly, they must address a time frame, May of 2025 at the end of the IEP year. All right, so in this goal, what is the behavior? You can come off mute or put it in the comments.
Read independently.
Sarah will read independently. Yes. What is the condition?
When
Second
presented
grade
with
reading
second
material.
grade reading material.
Yes. Great job. And the criteria?
80 words.
80
per
words
minute.
per minute with no more than 3 errors.
Yep. And the time
They're
frame.
missing one part here though, I think.
What's that?
And I mean, this may be my district nitpicking on stuff, but at the end of this, we have to say how it's being measured. So it
Yes.
has to say as measured by reading assessments given in her ELA class or something like, but it has to say how it's being measured.
And some districts incorporate that into the goal, and some districts put that underneath the goal in a little how it's measured.
Yeah.
So yeah. And then the time frame in this one is that 36 weeks. Yep. All right. Short-term objectives or benchmarks are statements that describe the steps to be taken to reach the annual goal. They are measurable, listed in order. So like, for example, that goal we just read in 36 weeks, it will break that goal down into 4 parts or 3 parts, usually aligning with whenever progress reports are sent out. So in 12 weeks, she'll be reading at 60%. In 24 weeks, she'll be reading at 70%. So it's breaking down that annual goal. These are not required except for children who take alternate assessments. So if your district has these on your IEP, just don't say anything because they're really cool and they're really easy to follow the progress. So it's definitely something that is great to have on there, but it's not required unless the children take alternate assessments. You can always ask to have them put on there, but again, it's not required, so the district can say no. All right, so we know who the student is, what they will learn. So now we're going to look at what will help the student learn. What does the student need in order to progress towards their goals and access and progress in the general education curriculum? So this is where our accommodations come in. They do not change the content to be taught. Instead, it changes the way the material is presented. They can involve many kinds of techniques, strategies, and support systems. They can be provided for instructional methods, assignments and assessments, learning environments, communication systems, schedules. Examples of these, I think you've all seen these before: preferential seating, read alouds, separate setting to take assessments, take a break, visual schedule, use of a calculator, transition prompting. It can even be, I know when my son hit middle school, he did not want he got very concerned about wanting to stick out, so he didn't want to ask for extra help. So he had a sticky note that he would put on the side of his computer, and that would initiate the teacher to come over and check on him. So it can really be anything that you can think of. And then we have modifications. And modifications alter the curriculum to meet the needs of the student. And modifications may be necessary in order for the student to be able to participate in the general education curriculum. And the decision, oh, sorry, guys. The decision to make modifications should not be made lightly, because modifications can imply that the student will not reach the standards for all students. But this can include anything from like half of a spelling list, partial completion of course requirements, teaching less material. My son had a modification for in multiple choice answers, the distractor answer would be taken out. So he had 3 things to choose from instead of 4. Shorter assignments, different things like that are modifications. And then we must also consider special factors. So children with limited English proficiency, the communication needs of the child, whether they need assistive technology, and then of course, parent concerns. What are your concerns? Another important consideration is in the case of a child whose behavior impedes their learning or that of others. The IEP team must consider the use of positive behavioral interventions, strategies, and supports. Please note that word positive. Behavior goals and plans should not be punitive in nature, but should contain positive support and strategies. A functional behavioral assessment is a tool that can be requested as part of an initial evaluation or reevaluation, or really any time if you're seeing an uptick in behaviors. And again, these are behaviors that impede their learning or the learning of others. There are the process, the FBA, the functional behavioral assessment, is the process of learning about how their behaviors are triggered, know when and where they're most likely to happen, so we can plan those positive strategies to teach new behaviors. And
I have a question on that.
Yes.
Sorry, you can go ahead. I just want to make sure you didn't go on.
Go ahead.
I have a child with increasing behaviors. She's 6 in first grade, to the point she's eloping out of school. I've mentioned looking into getting a functional behavior assessment, and they are reluctant to do that. Should I trust them?
I would ask for it in writing, because then they have to respond in writing.
Right. So they say, well, we're doing everything that we need to be doing. We are, and they are right now, but who's to say her situation doesn't change, or the administration changes, and then I don't get that anymore, or she doesn't.
So my reasoning behind that is, if they are doing everything they should be doing, why is the behavior still happening?
Right. And getting worse.
So I guarantee you, in a prior written notice, the school is not going to put down, we are not going to do an FBA because we're already doing what we should be doing. And that is the reason we want to do that in writing, because the school, it's a lot easier for the school to say something to you versus putting it in writing.
Okay. Thank you.
Yeah, you're welcome. All right, additional services that may be needed. Transportation, therapies, speech and language, sign language interpreters, assistant technology. We need to look at any services that are required to help the child access that general education and FAPE. Transition to adulthood, students between 14 to 21. Transition services that need to be addressed as employment, further education training, daily living, community participation. We are going to have a lunch and learn on transition services in particular in January, so I'm not going to get into too much of a detail in here. just that they have to be linked back to the yearly goals. And one of the things that I want to make sure that I say in the IEP, there's a statement on it if a referral needs to be sent to Kansas Vocational Rehabilitation Services, so VR services. I always want this box to be checked yes. And the reason is because VR is the one that does the assessment to see if they're eligible for those services, not the high school. So if they have an IEP, then they are potentially eligible to receive those voc rehab services. So I always advocate for that box to be checked yes and a referral to be made. So then VR can do its assessment and see if the child is eligible. That can be funding for college. That can be job skill coaching, helping find a job, getting bus passes to get to and from job. My 23-year-old son is just now, he had an IEP in high school and he didn't want VR services afterwards, even though he was eligible. But now he does, and they're helping him get a bus pass. They're doing job coaching with him. They're doing some additional training. It's a great service. And so I really think that if they have an IEP, they need to be assessed to see if they qualify for those services. An IHP, Individualized Health Care Plan, is written by the parents, the IEP team, the school nurse, and that can be put into the IEP. And then finally, we want to see, or not finally, but next we want to see who will help the student. This is going to be support for school personnel, gen ed teachers, special education teachers, related service providers. We're going to go into supplementary aids and services that are provided in regular education classes or other education settings, also in extracurricular and non-academic settings. These can support environmental needs. Talks about the level of the staff support that's needed, planning time for collaboration, and many other things. All right, so where the student will learn, this is where we're going to talk about least restrictive environment, the where of the IEP. By writing a student's IEP in a way that is tied closely with gen ed, least restrictive environment is more likely to be in the general education setting. It states that to the maximum extent appropriate, children with disabilities are to be educated in general education classes with their non-disabled peers. The IEP must have a statement explaining why, if any, the student will not be participating with their gen ed peers. Unacceptable reasons for placing students in a more restrictive setting. Lack of personnel. Sometimes we hear that a lot. Lack of space. Lack of funds are a few of those. Placement is determined at least annually, is based on the IEP. So we write the IEP on what services they need, and then we decide where the child needs to be placed to receive those services. And it's placed as close to the student's home as possible. So each district or co-op is required to offer this continuum of placement options, the least restrictive being that regular class, that regular general education setting. Before a child with a disability can be placed outside of that setting, the full range of supplementary aids and services that could be provided to keep them in the gen ed classroom must be considered. And this is something to really pay attention to. So as we move down the continuum, we find different placement options such as special classrooms, so resource rooms, special schools or alternative schools, home instruction, and this is not homeschooling. Home instruction is provided by the district and is utilized when a child's health would be jeopardized if they attended school and is meant to be short term. And then that instruction in hospitals and institutions. In foster care world, we see a lot of this as PRTFs and QRTP programs, so that when the team decides that the placement move is necessary, it's always a good idea to include when the team is going to reconvene to determine when the student will start transitioning back to a less restrictive environment, because that's always the goal. The goal is always to transition back more and more percentage of the time into a less restrictive environment. Each district, as I said before, must offer this continuum. Then we find a really high percentage of foster care kids in those alternative schools as behavior schools. Not inclusion, not mainstreaming. If we see that, we need to talk to the team about how we can transition that way back. There's nothing in law that says that you have to reach that gold standard in 6 weeks to go back. All right. I did want to mention one more thing. Districts are required to each district or co-op is required to have these, but not every school has to have them. So districts can cluster. So if it's determined that the child needs a placement in an alternative school, they might not be going to their home school, but the district will be required to provide transportation to that. All right.
Good question.
Yes.
What happens if a child refuses the service?
Well, then we have a problem because we have to have our kids buy-in. I would go back to the IEP team or maybe set up a time to have a phone conversation or a Zoom meeting with the kiddo to see why they're refusing that service and what they would be willing to do, because we can't force a kid to do something. We know how that goes and it doesn't turn out well. All right, and so then every year we have to review and update that IEP, and the process starts all over again. And remember that you can call an IEP meeting at any time, and IEPs do not expire. If you go past that annual review date, the current and the last agreed upon IEP will stay in force until you guys can meet and review the IEP. Right, upcoming training opportunities. We have several 1-hour trainings happening in 2024 and 2025. Remember, your retraining is by calendar year. This class will take care of your 2024 retraining requirement. We do have some classes already set in 2025 if you would like to sign up for that. Tomorrow, I'll be sending you a copy of tonight's PowerPoint, a certificate showing that you have completed this retraining, as well as a link for a quick evaluation of tonight's training. Here's all of our contact information. What questions do we have? I know we're a little bit over our time.
So I see one that says, I'm sorry to jump in. It says, are they allowed to send kids home because of behaviors? And for clarification, I asked what behaviors. It says self-harming. So I don't know. I mean, in high school at my district, they can suspend up to 10 days before an MDR has to be called to see whether or not it's a manifestation of the child's exceptionality. But
yeah, that's federal law. Yes, they can send the child home, but we want to make sure that it is marked as a suspension. And in Kansas law, it states that if a child is sent home for any part of the school day, even the last 10 or 15 minutes, that counts as one school day of suspension. So we want to make sure that we are getting those marked as suspensions because, as Michael said, after 10 of those, we're required to convene an IEP meeting, a manifestation determination review. We're required to see if the reasons for these suspensions are because of their disability, and if they are, to come together and see what we can add to and strengthen in that IEP meeting. Or if an FBA hasn't been done, do an FBA, write a behavior plan. So yes, they can, but we want to make sure that they're getting marked as suspensions. I'm gonna stop sharing real quick, guys, so I can see your faces.
I have a question.
Yes.
I have been to a couple IEP meetings where everything was verbal and I did not have anything in writing given to me before the meeting started. So I was really struggling to figure out what was going on. I think, and then they said they had a draft IEP, but it had not been shared. I don't like that.
I like to have a draft IEP also. There is nothing required in law that says they have to give you one. I always request it, but they do not have to provide it. What I usually do is I take notes, or I have last year's IEP in that meeting, and I write on the IEP the changes that the school is proposing so that I have something to match up with the prior written notice that I get.
Or you can always say, I need a couple days, can we reschedule the meeting? And then you can take whatever they provide you there and go through it.
Absolutely. Yep. You do not have to sign a prior written notice and give consent for services change right there in that meeting. You absolutely can say, hey, thanks for the meeting. I'm going to take this home and review it, and I'll let you know if I have any questions.
Just to clarify, you're going to send us the link for the evaluation so that we can get the credit for tonight. Is that what you said?
Yes, I will send to you a copy of the PowerPoint. Brian's been taking attendance, so we'll get you guys credited and your files marked that you've completed this year's training, and you'll get a certificate showing that you've completed it. And then I'll give you a link to an evaluation for tonight.
In the email?
Yes, in the email that I will send tomorrow.
All right,
because guys, I'm tired at 7:15. All right.
Am I able to ask one quick question?
Oh, yep. Go ahead.
When you're talking about the attendees of the meeting, I have a 17-year-old foster kiddo, and she has a no contact order with her parents, but the parents wanted to be on the IEP meeting, so she could not attend her own IEP meeting. Is there
Okay.
any laws around that?
There's not. The
Okay,
guidance
so
that
she
we have
just can't.
received, well, the guidance we received from KSDE is that the school can hold 2 meetings. They can hold a meeting with the student, and then the student can leave, and then they can invite the parents in.
Gotcha.
And there's also there's some schools that when they get to high school age, their IEP coordinator or transition coordinator will help them put together like a little PowerPoint for them to share in their IEP meeting. I think that's a really cool way for them to be involved and show, you know, what they want to do and what they think they need to have in their transition services for after high school. And that can be, you know, given and shown. The student could record it or something and send that in. So there's lots of different ways around that, but absolutely the students should participate in whatever the way they can. Absolutely the parents should participate in any way they can.
Okay, thanks.
You're welcome.
Can we answer, because I'm curious about this one. I'm sorry. Sherman has a really good question. If an extension is needed, the prior IEP stays in place for as
Yes.
long as it's necessary, even if it runs over the calendar year?
Absolutely, yes.
Okay, because he's saying the IEP coordinator pushed for a meeting saying there was a deadline at which the kiddo would not get services anymore. So this should not happen?
No, absolutely should not happen.
Okay.
Absolutely not.
But it might happen if the kid was DD and the kid turned 10.
Yes, you're correct on that. On the services specifically related to that. But if that's kind of a sticky situation because they technically still have an IEP, they technically still have to receive their services. So I would not want to see, I would think the school would not want to stop services even for a developmentally delayed that goes past the date.
Looks like Jeffrey might have a question.
Yeah, thank you. I've got a district that I've worked with for years, and I was just curious how to politely combat the fact that they always insist that my foster kiddos have their previous school records in place before they allow them to attend the school. And I've had it take up to 2 weeks before, well, 10 days has been the longest, but close enough to 2 weeks.
So
So how do I,
the
because I
so
work with the district a lot, I get along well with the district. I don't want to make a lot of waves, but yet I acknowledge that they shouldn't be doing that to
yeah.
us.
Have you talked to the special education director?
I haven't talked to the special education director. No,
I
it's whether
yeah,
they be or
I
not. I would that law is applicable. Is what I've been told. So
yes. Yes, absolutely. And if you would like to, Brian, if you wouldn't mind maybe jotting down Jeffrey's name, I can send you the specific law out of ESSA and maybe just sending that saying, hey, I was on a training last night. They mentioned the Every Student Succeeds Act that states foster children are to have immediate enrollment. How can we make this happen? Maybe just putting it something as simply as that. And I can
okay, thank
send
you.
you the exact wording. Yep.
I appreciate it. I'm probably going to be reaching out to you shortly with a particular case anyway, if that's all right.
Absolutely.
Thank you for everything this evening.
You're welcome. All right, guys, I've held you here way past your time. As always, please email me. If you had a question that didn't get answered, give me a call, send me an email. My job is to help you, so please keep me employed. My teenage kids' gas monies will appreciate it. All right, so
Thank you.
thanks for jumping on tonight. I hope you have a great evening.
Thanks, you too.
Thank you.
Thank you.
Thank you.